Thomas concurrence. You can answer that question, can't you?
In the abstract, yes. In reality, what you're describing does not exist in the UC system.
Okay, so Justice Thomas got it wrong. Is that what you're saying?
I'm not saying that.
Well, you are saying that because he was praising the policies of the University of California. You seem to be saying now that any university that gives a preference to low-income applicants is engaged in illegal DEI, or if they put a focus on first-generation students, that's somehow impermissible. After all the years of criticism of cancel culture, you seem to want to cancel any institution that has views that you disagree with.
A heated Senate exchange today pulled back the curtain on a growing fight over civil rights enforcement, free speech, and how far the federal government should go in reshaping universities and public institutions. Senator Adam Schiff confronted Justice Department official Harmeet Dhillon in a clash that went far beyond DEI slogans and landed squarely on constitutional law and presidential power. If you want reporting that explains what moments like this really mean, not just the viral clips, be sure to subscribe to the channel now.
Thank you, Chairman. Ms. Dhillon, you recently announced that DOJ was launching an investigation into the University of California over its UC 2030 capacity plan, which notes that future growth of faculty and students should result in campus populations that better reflect and tap the talent of underrepresented populations who represent the majority of Californians. In the SFFA versus Harvard opinion, the Supreme Court held that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, allowing universities to continue assessing students' experience with race on an individualized basis. In that opinion, in his concurrence, Justice Thomas praised the University of California for achieving diversity through race-neutral policies, including preferences for low-income applicants and first-generation students, and recruiting efforts targeted at areas with substantial populations of people of color. Are the race-neutral policies like those used by University of California, which Justice Thomas explicitly praised in that opinion, now considered by you to be illegal DEI?
Well, Senator, first of all, the investigation that we've opened is an investigation, and it's an investigation into the hiring policies of the University of California system, not the admissions policies. That said, I have absolutely seen abuses in the admissions policies in using race as a crude proxy for discrimination. That's not the question I asked you.
Are the race-neutral policies praised by Justice Thomas now considered by you to be illegal DEI?
I think you're mixing apples and oranges.
Well,
so I can't really answer your question.
You can answer my question and say, yes, they are now illegal. That is what Justice Thomas praised in terms of race-neutral policies, which include preferences for low-income applicants, first-generation students, things like that. Are you now saying that what Justice Thomas praised is now illegal in your view?
Senator, there's a difference between what you see on paper and what you see in reality, and I reject your premise.
I'm not asking you about particular.
I reject your premise that how California describes its admissions practices is
about whether
reality.
You subscribe to the Supreme Court's opinion or whether you disagree with Justice Thomas' concurrence. You can answer that question, can't you?
In the abstract, yes. In reality, what you're describing does not exist in the UC system.
Okay, so Justice Thomas got it wrong. Is that what you're saying?
I'm not saying that.
Well, you are saying that because he was praising the policies of the University of California. You seem to be saying now that any university that gives a preference to low-income applicants is engaged in illegal DEI, or if they put a focus on first-generation students, that's somehow impermissible. After all the years of criticism of cancel culture, you seem to want to cancel any institution that has views that you disagree with. In answer to the questions about law firms, you want to cancel law firms because they take on unpopular clients to you, to the administration. That is, if a firm represents someone with an adverse interest to the administration, which is their First Amendment right to do, and I would also say their duty to do, you would cancel them. You would cancel universities like Harvard or the University of Virginia that take positions and exercise their First Amendment rights contrary to what you think the administration wants to see. You would cancel the Associated Press for not using the ridiculous nomenclature of the Gulf of America. You're canceling now the Wall Street Journal because the Wall Street Journal had the audacity to publish an article about Trump's connections to Jeffrey Epstein. So this is what's going on in this administration. You've devastated the Civil Rights Division. Hundreds of attorneys, 368, have departed since January of this year. There's been a mass exodus from the Civil Rights Department. It is just a shell of what it used to be. They're being canceled. They're being canceled by you, by the department. Anyone that stands up to this president is at risk of being canceled. And I think what you're doing to use the sledgehammer of federal funding with universities to try to coerce them to accepting your right-wing agenda is disgraceful. And using that cudgel will have far-reaching implications, attacking research done by universities, academic independence done by universities. It will establish a dangerous precedent that can be abused by a president of any party, and we should recognize that on a bipartisan basis, even though it does not appear that we do. I yield back, Mr. Chairman.
Thank you. Senator Kennedy.
The confrontation unfolded as Schiff questioned Dhillon about the Justice Department's decision to investigate the University of California system. The investigation centers on UC's long-term growth plan, known as UC 2030, which aims to expand faculty and student populations in ways that reflect California's changing demographics and better reach historically underrepresented communities. Schiff began by grounding his questions in Supreme Court precedent. He referenced the Students for Fair Admissions versus Harvard decision, which restricted the use of race-based admissions. But Schiff pointed out a critical nuance often lost in public debate. The court explicitly stated that universities may still consider how race has affected an individual applicant's life experience, as long as decisions are made on an individualized basis. Dhillon responded by narrowing the scope. She said the investigation focuses on faculty hiring, not student admissions, and argued that what universities describe on paper does not always reflect how policies are implemented in reality. But Schiff pressed further. He was not asking about alleged abuses. He was asking whether the Department of Justice still accepts the Supreme Court's guidance, including Justice Thomas's praise of race-neutral diversity strategies. As this exchange continued, it became clear that the disagreement was not just about UC of California. It was about whether concepts like supporting low-income students or first-generation applicants could now be swept into a broad definition of illegal DEI. If this legal context is helping you make sense of the debate, take a moment to subscribe. Understanding the law matters in moments like this. Schiff cornered the issue with a sharper question. If Justice Thomas praised UC's approach, and the Department of Justice is now investigating UC for similar policies, does that mean Justice Thomas was wrong? Dhillon resisted that conclusion, saying Schiff was mixing abstract legal theory with practical reality. Schiff countered that she was effectively rejecting the court's reasoning by dismissing the policies Thomas praised as non-existent or improper. From there, Schiff widened the lens. He accused the administration of weaponizing the idea of cancellation while claiming to oppose cancel culture. He argued that the government is using federal power to punish institutions that take positions it dislikes. He cited examples: law firms being targeted for representing clients unpopular with the administration despite their First Amendment right and professional duty to do so; universities facing pressure or funding threats for exercising academic independence; media organizations criticized or excluded for refusing to adopt politically preferred language or for publishing reporting critical of the president. Schiff framed these actions as part of a broader pattern, not reform, but coercion. He then turned to the Department of Justice itself. Schiff stated that hundreds of attorneys have left the Civil Rights Division since January, describing it as a mass exodus that has hollowed out the department's capacity to enforce civil rights laws. In his view, the very division meant to protect constitutional freedoms is being dismantled from within. Before we move on, make sure you're subscribed. These issues affect higher education, free speech, and civil rights nationwide. Schiff ended with a warning that went beyond partisan lines. He argued that using federal funding as a blunt instrument to force universities into ideological compliance sets a dangerous precedent. If one administration can do this, so can the next. Academic research, institutional independence, and constitutional protections all become vulnerable when enforcement power is driven by political loyalty rather than law. His final point was a reminder often missing from these debates. Civil liberties do not belong to one party. Once eroded, they are difficult to restore. This clash was not just about DEI. It was about who decides what is permissible in education, who defines civil rights enforcement, and whether constitutional safeguards remain intact when political power changes hands.